Okay, so good morning everyone. My name is Lalit Soni and you are watching Drishti IAS. In this live session, we'll be discussing Indian Express newspaper. As usual, we'll be covering important news article which can be important for your examinations. So let's start. We'll start with the practice question which was given to you in the previous lecture, and then we'll go to the next section, that is Know Our Constitution. So we'll talk about the further few more articles related to DPSPs. Okay, and then we will go to the important articles of the day. There are certain guidelines which has been issued by the ministry with respect to the foster care. Okay, so when we are talking about the fostering a child, or there is this adoption, so there are there is a difference between adoption and fostering. In India, we are not quite familiar with the word foster, so we will be talking about that. We will see what kind of guidelines or what kind of changes which has been made over there. Okay, then moving further, working of the collegium in the question again. So when we are talking about the collegium or the method of appointment of judges, so it has always been somehow, you can say that it was somewhat opaque, so that is why it was again in question. Okay, so we'll be talking about that. Then what is Hayflick limit? Okay, so the person who has founded this Hayflick limit, he died recently. The scientist named Hayflick himself died recently, and because of which this particular you can say topic was again in news, and we will be trying to have a look at what is Hayflick limit and what it relates to. Okay, so these are the important articles. Other than that, we will be discussing 2-3 more articles that will be important. Okay, in the end there will be a question for your practice. Okay, so let's start. We'll start with the practice question which was given to you in the previous lecture. Which country is the primary source of imported solar panels for India? When we are talking about the imported solar panels, as I told you that we are quite dependent on China with respect to the solar cells. Okay, in India also what we are trying to do is we are trying to make these solar modules. Okay, but the thing is that is not very much a manufacture, but mostly on the line of assembly. Okay, so what we do is we import the solar cells from China, and then we try to assemble them over here and try to create a solar module. Okay, so option C is your right answer, that is China, because we are kind of dependent on China for that. Okay, now coming to the next part, that is knowing our constitution. As I told you, we were on the part 4, that is directive principle of state policy. We have discussed 2 articles yesterday. I told you that there is this definition which is given, definition of state, which is given in the article 36, and then in 37 the application of DPSPs has been given. Moving further, we have seen 2 articles yesterday. That was, one was related to your 38, that was related to, you can say that to remove the socio-economic inequalities. Okay, so that was there, and then there was this article 39 which was kind of related to right to work and equal payment. Okay, so that was there. You can go through this particular articles over here. We have discussed it yesterday. These are the articles which are based on the socialist principles. Okay, when we talk about Indian constitution or the directive principles which are given in the Indian constitution, there are 3 principles which has been followed. One was your you can say socialist principle. These are more or less based on the Nehruvian socialism, and then there is this liberal principles are also used while writing the DPSPs, and then there are Gandhians. Okay, so we'll try to look at them separately. So first, as I told you that these are the socialist principles on which these DPSPs are based. One was related to your ensuring socio-economic and the political justice by minimizing the inequalities. Second was related to your right to work and the equal payment. Okay, so that these are over here. Now coming to the next one, that is based on the socialist principle, that is article 41. Okay, now article 41 says that to secure the right to work, to education and public assistance in case of unemployment, old age and sickness and disability. It looks like that this is something state should do. Okay, now the thing is, because of the lack of resources, state is not able to do it to the full potential. Okay, so that is article 41. Then article 42, the state shall make provision for securing just and humane condition for work for maternity relief as well. Okay, so you know that for this we have laws. Okay, so that is enforceable, we can say. Then moving further, article 43, the state shall endeavor to secure all workers a living wage and a decent standard of life. Then article 43A, when we are talking about such A, B, C, which are the suffix which has been used in the constitution, that means that there has been an amendment. Okay, there was earlier we had article 43, and later this article or this provision has been added, that is article 43A. The state shall take steps to secure participation of workers in the management of the industry. Here you can see that here we are saying that to secure all the workers a living wage and a decent standard of life. Okay, then it was felt necessary that in management also the laborers should have a say, or you can say these are also stakeholders in the industry, that is why they should also have a say, and that is why we have actually introduced this article. Okay, moving further, article 47, to raise the level of nutrition and the standard of living of people to improve the public health. Now you can see all these rights, mostly when we are talking about the work, these are your economic rights. Okay, when we talk about health, this is, you can say that somehow it is a social right. So these are talking about the socio-economic rights. As I told you, these are based on the socialist principle. So you will be seeing that the workers are given prominence over here, or you can say workers right has been given prominence over here. Okay, so that is about the socialist principle based DPSPs which we have discussed. Then now we will be moving to the discussion of article. Okay, so revised guidelines expanded eligibility, single parent can foster children, adopt after 2 years. Okay, now when we are talking about the fostering means a temporary you can say guardianship which has been given to a person. Okay, when you talk about adoption means that you have adopted a kid to be your child now. But when we are talking about fostering, that is, you can say, a temporary guardianship which has been given to you. Now as per this new change which has happened over here, there are two changes which are there. One thing is a single parent can also go for fostering a children. Okay, earlier it was not there, earlier you have to be married. Okay, then second is adopt after 2 years. Okay, a person or a child which is in custody of a guardian for like 2 years, or you can say he is the foster parents of that particular children, later after 2 years he can go for the adoption. Okay, now again when we are talking about the fostering, it is a temporary provision, because once the biological parents are able to take the responsibility of that particular kid, that has to be returned. But you know, many cases if there is some kind of issue, or you can say parents are not able to take the responsibility of that particular kid, in that case you can file for the adoption as well. Okay, now coming to the difference between the foster care and adoption, and then we will come to the provisions. Okay, now adoption is the permanent arrangement where parents legally take the responsibility of a child and she becomes the member of the family. Okay, that you had adopted a child and she is becoming the member of your family. Now she will have rights as well. Okay, so that is there, that is adoption, and it is a permanent you can say arrangement which has been made. Now coming to the foster care, on the other hand, foster care, if we talk about, this is a temporary arrangement. Okay, in which a child temporarily lives with either extended family or unrelated individuals. This arrangement is intended for children whose parents are unable to take care of them due to circumstances like illness, death, abandoned by one parent, or other you know, some situations which are there, because of which the biological parents are not able to take care of that particular children, and that is why that can be, you know, given to the foster care. Now when we are talking about the foster care, as I told you, this is a temporary arrangement. If the biological parents are able to take the responsibility after some time, they will be given the, you can say, wardship. But when we are talking about the case where it is not possible, after 2 years you can go for the application of adoption, and then you can go for, you can say, permanent arrangement. Okay, now talking about the changes which has been made, when we talk about this particular issue of foster care or adoption, there are certain rules here. You can say Juvenile Justice Care and Protection of Children Act 2021 which is there, and then there are Juvenile Justice Care and Protection model rules also there, and the change has been made in these two. Okay, so we have a statutory law which is taking care of the issue, and on the basis of which there are certain changes which has been given over here. Here you can see in now they have permitted single individuals, including who are unmarried, widowed, divorced, legally separated between the age of 25 to 60 years, to foster a child and adopt for after 2 years. Okay, so which we have seen. Now here one catch was there, earlier it was not there. Earlier you are not supposed to foster a child if you are a single parent. Okay, so that is there. Now however while a single woman can foster and eventually adopt a child of any gender, okay, so if there is a female and she is single, she can adopt a boy as well as a girl. Okay, but when we are talking about a single male, he can only adopt a boy. Okay, so that is the case. However, while a single woman can foster and eventually adopt a child of any gender, a man can only do so for a male children. Previously, under the 2016 model foster care guidelines, only married couple referred as both spouse in the old document were permitted to foster a child. Okay, as I told you earlier, single person was not allowed to foster a child, even adopt a child. Okay. Now moving further, here you will be seeing in India, the children who can foster have to be above the age of 6 years, living with child care institution and having unfit guardians. Okay, so the age for the kid to be fostered is 6 years. Okay, so you can remember that. Now the revised guidelines also allowed the foster parents to adopt a child after she has been in the foster care for minimum 2 years as opposed to the 5 years earlier. Earlier this provision of 2 years was for you can say the time limit was more, that is 5 years. Now it is 2 years, so that is also one change which has happened. Now another thing is, if you are going for you are a couple and then you are going for fostering a child, then your relationship should also be stable. Okay, your marital relationship is there, that should be stable. Otherwise you are not supposed to foster a kid, because ultimately that will have when we talk about the foster kids or the kids which are under the you can say care institutions etc., they have some kind of trauma attached to it, because obviously if their life is not you can say normal, and that is why they are in the you can say care institutions. So there can be some kind of trauma which is attached to it, and now if the foster parents are also having similar issues, that can even have a a negative impact on the health of the child. Okay, so that is there. Now since single individuals are allowed to adopt children but were not allowed to foster as per the earlier guidelines. Okay, so as I told you earlier, when we talk about the guidelines, there were you can say they are allowed to adopt a kid but not foster, because first changes has came into that document and now they are coming to this. Okay, now moving further, age factor. Okay, so most of the time you will be seeing that both spouse or the you can say male and female, if they are couple, that should be age of 35 and above. Okay, or the composite age can be 70. Okay, composite age means in some cases they will be looking at the age together, so that is composite age. Okay, and here you will be seeing the fostering a child from the age 6 to 12 years and 12 to 18 years. Okay, now there are various brackets which has been given in the law with respect to the age. Now this is not important for you, as we have seen that there is this age which is given, that is 25 to 60. This much will be important for you to understand that this is the bracket in which with certain condition you can go for the fostering of the children. Okay, so you don't have to remember all these age for like different cases, different age is given, that is not important for us. Okay, now what is happening after that? Once you have decided to go for the fostering, then you have to register online. Okay, there is this platform, that is Caring, that is Child Adoption Resources Information Guidance System. Okay, so that is there, so you have to register on that, and then you have to abide by certain rules which are there, and ultimately you might get the custody. Okay, the number of children in the foster care are few. People do not know about the foster care as well as they might know about the adoption. When we talk about India, mostly people are aware of the adoption, but they are not aware of the foster care, because when we are talking about the you can say parentage is some kind of sentimental. Okay, and when we talk about adoption gives you a permanent attachment or the permanent arrangement, that you might feel the attachment in that case. Okay, but fostering, in the case, there are every person might not be that much empathetic. Okay, and that is why in India we don't have such system. We are not well versed with the system, but in India also this exists, so that is there. Okay, but the most prominent or the you can say most common is adoption over here. Okay, so that is about the various changes which has been made in the guidelines related to the fostering and adoption. For your examinations point of view, just 2-3 things are important. That is, one, what is the difference between foster care and the adoption. So this particular paragraph will be important for you. Other than that, two changes which has been made, that is related to single parents can also go for the fostering, and the after 2 years they can go for the adoption. Earlier, what was the scenario? Earlier, single parent could not go for fostering, and earlier this particular time was 5 years. Okay. So that is all about this. Now we can move to the next article, which is related to the collegium. Recently there was this case in Himachal Pradesh High Court. Judges posting collegium notes came under the Supreme Court scrutiny. What has happened was, there were certain names which has been recommended by the Supreme Court collegium to the High Court, but at the time of the appointment they did not consider their name. So these two judicial officers gone to the court, okay, that why these names were not considered, and if at all there was some kind of communication which has happened, then what is the way through which these communication is happening. When we talk about collegium, collegium is a system that is appointment of judges by the judges itself, okay. It is known as that, and it is criticized to be opaque, okay, because what is happening inside the closed door of that collegium, so we don't know, okay. Now considering the recommendations which are made by the collegium, what happens is that these names will be given to the ministry by the collegium. And when we talk about what is collegium, we will be seeing that what is the composition of the collegium, but these names are recommended from the you can say Supreme Court's collegium to the ministry. Ministry will give it to the, you can say, Council of Minister or the PM, and then PM will give it to the President, and President will go for the appointment, okay. Now in the whole process, if the government thinks that there is some name that should be changed, so that is why they can send it back for the reconsideration. But if it comes, you can say, with or without changes, then they have to accept it, okay. So here you can see that judiciary is having a prominence over executive with respect to the appointments of the judges. It is said that judiciary it is considered under the independence of the judiciary, okay. But again, this is kind of a, you can say, opaque or non-transparent method. So we'll be talking about that. So this was the issue. We don't have to go in the issue. Now Supreme Court will be hearing this, okay. So that is there. Right now, coming to the point, that is what is collegium system. We will try to understand how this collegium system has came into picture, okay. Now collegium system, it is a system of appointment and the transfer of judges that has evolved through the judgment of the Supreme Court and not by an act of parliament or by provision of the constitution. The word collegium has not been mentioned in the constitution. They have not defined in the constitution, okay, but the authority has been derived from the constitution itself, and this was a construct of Supreme Court itself or the court itself, okay. Now here you can see it has come through the judgments of the Supreme Court. In that regard, there are 2-3 cases which are quite prominent. Before that, we will be seeing what from where this authority is coming. So here you can say constitution provision related to the appointment of the judges, okay. Article 124 subclause 2 and article 217, appointment of the judges of the Supreme Court and the High Court. President makes appointment after consulting with such judges of the Supreme Court and the High Court as he or she may deem necessary, okay. Now it is made made clear over here that there should be a consultation with the judges. Now this word consultation, whether this consultation should be binding or not, that was the question, okay. Now let's see. But the constitution does not lay any process for making such appointment. As I told you, there is no process given, and that is why Supreme Court has interpreted it in a such a way that now we have collegium system, okay. Now here you can see evolution of the collegium system. As I told you, this word consultation is the bone of contention over here, okay. The Supreme Court in this particular case, that is first judge case, that is in 1981 there was this case which has been given. In that particular case, it was questioned that this word consultation, whether it is consensus or just the advice, okay, or you can say just recommendations, or you can say there should be a consensus, or you can say that should be a binding or not, okay. So here Supreme Court held that in appointment of a judge of Supreme Court or High Court, the word consultation, which was used in Article 124 clause 2 and in Article 217 of the Constitution, does not mean concurrence, okay. So they are saying that it does not mean concurrence. That means that who will have the supremacy here? Executive will have the supremacy on the judiciary, okay, because since consensus is not there, okay, or the concurrence is not there, that means that executive can take a decision by themselves as well, okay. So in that particular situation, what we can imagine is that Supreme Court has given the name. executive did not like it, so executive has appointed as per their wish. Okay, so that is the condition as per the first judge case. Okay, then after some time there was this second judge case. Then when we are talking about the second judge case, again the question was same. Okay, Supreme Court overruled the first judge case. Here they have said that no, the word consultation means the concurrence with the advice of the Supreme Court. Okay, so here it gave birth to the collegium system. Here they have said that since it is binding because it is concurrence, okay, that means that whatever Supreme Court is saying, then the government has to agree on that. Okay, otherwise there will be a blockage. Okay, so then second thing was when they are saying that the you can say consultation with the Supreme Court. Now with whom that consultation would be? Okay, with the CGI or the whole Supreme Court? How will you decide? Okay, so that is why we have come up with this particular thing, that is collegium. The birth of the collegium system premises to judiciary. Collegium included the Chief Justice of India along with the two senior most Supreme Court judges. Now they have decided that not everyone, you have to consult with the CGI plus two more people. Okay, now again whether these two people and the CGI should be having a consensus or not, let's say, or the decision should be taken as per the majority. So they have said that no, it should be based on the concurrence. Okay, if more than two judges in the, when we are talking about the third judge case, then this the new or the current form of the, you can say, collegium system which has came into picture, this is CGI plus 4. So in this particular case, right now if we talk about, this is the collegium. Okay, in India we have a collegium in which CGI will be there and 4 senior most judges will be there. Okay, and if any two judges says that this name should not be going, so in that case CGI will not send that particular name. Okay, so you can say somehow consensus should be there in this particular, you can say, a collegium. Okay, so that is there. But again, when we talk about what is going inside, what on basis of what material fact you are deciding the names of these people, that we don't know. Okay, so coming to the criticism part, what are the criticism of this collegium system? Here you can see opaqueness is there, scope of nepotism is there, exclusion of executive, because obviously you know that executive is not given prominence over here. Then no predetermined procedure of appointment. There is no procedure. What is going on inside the closed doors or the closed walls of the collegium, that is remaining inside that only. Okay, and second thing is you are not even you are not to question that as well. Other than that, you know that there was this amendment to the, there was that, you can say, NGAC, National Judicial Appointment Committee was there, but this particular committee or the law which was there for this committee, that was held unconstitutional by the Supreme Court, saying that it is taking away the independence of the judiciary. Okay, because in this particular committee, appointment committee, there was also law minister which was included in the appointment process. Now they have said that since judiciary is independent, there should not be any role of the executive over here. Okay, and that is exactly why this was held unconstitutional. So these are certain criticism of the collegium system. Okay, now this is about the collegium. Now we can move to the next article, which is related to the Hayflick limit. Okay, for your exams point of view, you don't have to go much deep into this particular discussion, but the thing is you should know what they are talking about. When we talk about Hayflick limit, in this limit it was understood that body, or you can say body, has its own rhythm or the clock, and there is certain age till where these cells inside the body will regenerate themselves. Okay, and that is the time when the cells stop regenerating themselves. You can understand that that is the time you will start aging. Okay, so earlier it was supposed to be that like if you are having this regeneration, constant regeneration of cells, then you can be alive for unlimited period of time. Okay, but after Hayflick, it was the notion which has been challenged. Okay, so recently Leonard Hayflick actually died, and that is why this particular question or you can say discussion is there. Okay, maximum number of times normal cells can divide, a biological limit for how long an organism can live. Okay, so this is the maximum number of time a normal cell can divide itself. That is basically your Hayflick limit. Okay, now let's say how it is working inside, or you can say etymology of this particular thing we can see over here. Now there was this biomedical researcher Leonard Hayflick, the picture is given, who discovered that the normal somatic cell can divide and thus reproduce only certain number of time. Okay, And Hayflick discovery fundamentally changed the understanding of aging, especially the thesis that the cells are capable of being immortal. Okay, as I told you, cell earlier there was this conception that cell can divide for any number of time, and until these you can say things are happening, you can be alive for a long time, or you can say you can be immortal if you are focusing on your diet and other aspects. Okay, so that was the case earlier, but after his discovery he discovered that the somatic cell can divide itself for a limited period of time, and till it can divide, then your or after that slowly you will be seeing your body is aging. Okay, so that is the case over here. Now, the cell division in somatic cells or non-reproductive cells stopped after roughly 40 to 60 times. The succession in the cell division is what Flick poised cause aging. Okay, so basically he is saying that as and when this process is stopping, then you will start aging. Hold on a second. Okay. So as and when this particular process is stopped, then you will start aging. Okay, and there is a limited time for 40 to 60 time, or you can actually the cells can go for the division. This limit will be different for the different species. Okay, so that is there. The succession in the cell division is what Hayflick posed as causing aging. Here you can say a senescent cell, or the cells which has actually stopped the division, okay, and they start accumulative inside the body, and that is how you start to age and decline. This means that there is an inbuilt cellular clock in the human body and that of any other organism which determines how long you can live. Okay, so that is what is called Hayflick limit. Okay, the number of time a cell can divide itself, and once it stops, after that you will be living for, or you can say you will be start to age. That particular limit for which the cell can divide is called the Hayflick limit. Okay, that is around, when we are talking about the human life, that is around 125 years if you are going with the better diet, etc. So that is 125 years. But correlation and causation, if we talk about after that, after Hayflick, there was more studies, and it was found that there are certain, you can say, component that is called as telomers. These are the telomers which are there on the chromosome. When we talk about the chromosomes, okay, at the end of the chromosomes we have telomers. Okay, now these telomers are basically decline slowly. Okay, and when these the thing is, the telomers are the repetitive DNA sequences at the very end of the strands, that means to protect the chromosomes. Crucially, with each cell division, these telomers get slightly shorter. Okay, so as I told you, that get declined. Okay, now eventually the telomers reach a critical point where cell division ends. Okay, as and when these telomers are shortened to a particular extent, after which cell division is not possible. So that is there. Then after that, there was also certain discoveries which are saying that there is this particular protein, that is telomerase. Okay, then telomerase is having a capability wherein it can actually help in the cell division, okay, or it can increase the cell division, but it was seen that it is most probably happening in the cases of cancer, okay, and otherwise not. So that is why Hayflick itself said that in the case of cancer, this particular Hayflick limit does not work, because in the cancer what happens is that the cell goes for the unlimited division, because of which extra cell growth is there. Okay, so that is about the you can say some exception is there, that is telomerase. Now this is one of the theory. Okay, so you don't have to worry much about it. If that is happening, then why other theories are also there, etc. Just know that what is Hayflick limit, that is limit to which a somatic cell can divide itself. Okay, so that is about, you can say, Hayflick limit. After that you will start aging. That was the hypothesis which has been given by the Leonard Hayflick. Okay, so that is about this article. That is all with respect to this. You don't have to worry much about it. Next is PM Modi's visit to Ukraine. PM will be going to Poland, and then on the flight back to India, meanwhile, or you can say he will go for a stopover in the Ukraine as well. And obviously they will be talking about the war situation which is going on in the Ukraine, that is related to Russia-Ukraine war. And you know that there was this peace process which is going on, and last time also in the Swiss peace process, India has this position that any kind of negotiation or the deal should be brokered after the involvement of both the parties, that is Russia as well as Ukraine. You know that in the last Swiss peace process, Russia was not there. Okay, so our stand here is clear that both the parties should be there, and that is how you can get to a solution. Otherwise, X party it won't be meaning anything. Okay, so that was there. Second thing was, other than that, they will be talking on the you can say political, trade, economic, investments, education, culture, people to people exchange, humanitarian assistance, etc. He will interact with the Indian community which is living over there. Okay, so all these things will be happening. So we will keep a tape on that. Now moving further, talking about the Israel and Hamas issues, you know that it is it has become like now a lot of time, and this issue is still there. Recently, USA has said that, or the USA has given the warning that this time, this arrangement or the whatever deal they are trying to broker over here, that will be the last opportunity for both of them to take that. Otherwise, there won't be any more meetings, or there may be some consequences that has not been made clear. But you can say that this time USA seems frustrated too, because there have been many round of talks. Okay, recent was in Qatar. Okay, so in that they have said that this is the bridging proposal, and this will be the last opportunity for both the countries over here. You know that Israel is adamant about eliminating Hamas altogether from this particular region, and Hamas has started, or they have actually threatened that they will go for the suicide bombing in Israel again. Okay, in the back, when we are talking about the past, there was also these issues of this you can say suicide bombing which has happened, and now Hamas are actually threatening again. Okay, so that is the situation as of now. Okay, Blinken's meet Netanyahu wants Israel and Hamas of the last chance to end the war in Gaza. Okay, what happens after that, that is for us to see later. And in the end, we have this article for your own read, that is calling Harappan civilization Sindhu Saraswati civilization in NCERT textbook is based on established scholarship and not just politics. Okay, so basically this article has been given, so you can go through this article. I have taken this because we have already discussed this issue of changes of the nomenclature in the NCERTs. So you can go through this article. There was this scholarly insight which has been given in that. Okay, in the end, there is this MCQ for you to attempt, that is, for the appointment of the Supreme Court judges, the collegium consists of the Chief Justice of India and 2 senior most judges of Supreme Court, 3 senior most judges of Supreme Court, 4 senior most judges of Supreme Court, or 2 senior most judges of the concerned High Court. Okay, so you can attempt this question and answer in the comment box. With that, I would like to take your leave. I'll see you in the next session. Till then, have a good day. Thank you. And if you have not subscribed the channel, please subscribe it. Have a nice day.